Yes, Mr. Rahman.
Sir, I appear on behalf of the respondent, Ms. Amanda Elizabeth Flowers, who is the claimant in this case. Today I am here to respond in relation to the defendant's application to set aside the default judgment which was entered by the court on 5th September 2019. Sir, you will find the relevant facts of this case in paragraph 1.2 of my skeleton argument. I do not propose to read out the facts unless you wish me to do so.
No, thank you.
Sir, if you kindly look at paragraph 3 of my skeleton argument, you will see the four main issues of this case. Those are, firstly, whether the defendant was drunk at that time. Secondly, whether the defendant was driving at excessive speed. Thirdly, whether there was any cat in the time of the accident. And finally, whether the damages caused because of the accident. Sir, the test for setting aside the default judgment is in paragraph 4 of my skeleton argument. According to CPR 13.3.1, the court may set aside or vary a default judgment if the defendant has a real prospect of successfully defending the claim, or it appears to the court that there is some other good reason why the judgment should be set aside or varied. Sir, moving on to my submission, which is in paragraph 5 of my skeleton argument. My first submission sheds light on the matter that the defendant has no real prospect of successfully defending the claim, and I have four reasons behind my first submission. Sir, the first reason is the defendant was heavily drunk at the time of the accident. Sir, after the accident occurred, the defendant was staggered into her home with her partner, and in that time Ms. Flowers saw the defendant, and her appearance clearly indicates that she and her partner both were heavily drunk. And sir, in her witness statement, Ms. Thomas stated...
Sorry, what evidence is there that she was heavily drunk?
Sir, my client, Ms. Flower, saw that they were staggered into their home, and their appearance was like that. Both of them were drunk. This is only a witness statement of Ms. Flowers.
Yes, but that doesn't mean that they were drunk, though, does it?
Sir, there are some other factors, and if we consider that, then we might be able to conclude that that there is a possibility that she was drunk in that time.
Yes, what are those other factors then?
Sir, another factor is that the defendant, Ms. Thomas, stated in her witness statement that she was with her partner in that day. The whole evening she was with her partner, and her partner was drinking. So there is a chance that she also drank with her partner. Although this is not an absolute evidence that her partner drank, that means she will drink, but there is a possibility. And moreover, after the accident occurred, Ms. Flowers called the police officers. Two police officers came for the investigation. They wanted to talk with Ms. Thomas. So the police officers went their home. The police officers were ringing the bell, but no one responded in that time. So this is another factor which we can take into account and conclude that there is a high possibility that as she was drunk, she failed to respond the ring bell. Sir, the second reason behind my first submission is that the defendant was driving in an excessive speed. Sir, in the day of the accident, my client, Ms. Flowers, heard, even before the accident, that a car is coming in an excessive speed. She heard the sound. And moreover, if she was driving slowly, she could easily control her car. And as the defendant is saying that there was a cat in the street, and in order to save that cat, she caused the accident. Although I do not agree with this statement, but for a minute, if I agree with her for the sake of...
Give me, Mr. Rahman, it matters not whether you agree with the statement or not. What is your submission in relation to the statement?
Sir, my ultimate submission is that there was no cat. But in order to establish the issue that she was driving at excessive speed, I want to figure out this point that even if there was a catch, if she was driving slowly, a single brake would be sufficient to bring the control of the car. But as she was driving very fast, that's why a single brake wasn't enough and she caused the accident.
Yes.
Sir, the third reason behind my first submission is that there was no cat in the street. Because the defendant, after the day of the accident, met with Ms. Flowers. They talked about this issue. they also watched both of their cars. But in that day, Miss Thomas didn't mention about the presence of the cat to Miss Flowers. So any person in the place of Miss Thomas would definitely in the first place mention the issue, if it is true. But from this we can understand that that there was no cat, and the defendant also failed to submit any evidence, as it is their application, so it is their duty to prove that they have a real prospect of success. But they failed to provide any kind of witness statement or any CCTV footings regarding the presence of the cat in the street. Sir, my fourth reason behind my first submission is that the accident was the sole reason behind the damage. Sir, if we consider some factors, we can easily understand that. In her witness statement, Ms. Thomas agreed that there was an accident and there was a collision between two cars. On the other hand, Ms. Flowers stated that she heard the huge noise after the collision. So, sir, this is practically impossible to argue that there was an accident between two cars, and after the accident there was a huge sound, but there was no damage. No one can argue that. So, sir, this argument is a bit ridiculous, that there was no damage, even both of the cars collided with each other. Sir, my second submission is in paragraph 5.2 of my skeleton argument, which is there is no good reason for which the default judgment should be set aside or varied. Sir, the defendant stated that she didn't get the claim form or particulars of claim because her ex-boyfriend deleted that mail from her mailbox. This is probably an excuse that the defendant is trying to make, as in the date of that accident, my client clearly saw that the person with her was not her boyfriend Lee Rogers, it was someone else. So there is a possibility that they ended up their relationship even before the accident occurred. And sir, if we look at the later conduct of the defendant, we can see that she failed to act promptly. Although there was a default judgment entered against her on 5th September, she received that on 6th September. And after receiving a default judgment, what should a person do? Either he should accept the judgment or he should apply to set aside. But after receiving the default judgment, Ms. Thomas went on a holiday after that day. And even after coming from the holiday, she wasted 5 more days. And later on 19th September, she talked with her solicitor. So, sir, from this we can understand that she
Yes, although from the layperson's perspective, you've got to appreciate that she may not have realised the severity of this situation. If she had already booked her holiday, she would have no doubt been stressed by that, or her mind preoccupied, and then she's gone on holiday.
Yes.
And attended to it when she came back.
Yes, sir, but it can be expected that even after coming from the holiday, she should act promptly. But even after coming back from the holiday, she wasted 5 more days. Sir, he didn't do anything illegal, but from this we can at least understand that she didn't successfully apply in quickly. And sir, this is her negligence, and for this reason she failed to submit the acknowledgement of service or or the defense in time. So, sir, from this we can understand that the defendant do not have any good reason for which the default judgment should be set aside or varied, as she didn't act promptly.
Yes.
And sir, my final submission is under the principle of overriding objective. Under CPR 1.1, the court should always consider the overriding objective to deal with the case justly and proportionate cost. As the defendant do not have any real prospect of successfully defending the claim, and there is no other good reason for which the judgment should be set aside or varied, so it is just and proportionate not to set aside the default judgment. And sir, my client has also waited for a few months, as she already repaired her car, which costs £870, and she is waiting to receiving the money. But as the defendant is doing too delay, it has been already spent more than 1 month that she is waiting. So, sir, I urge to the court to deny the application of the defendant and compel him to give the necessary compensation under the judgment. Sir, unless I can assist further, those are my submissions.
Yes, good. Thank you very much. Okay. Rafi, well done. That was a very good attempt there. You made some good points, and you took the court through the limbs of the test, and you outlined the skeleton well, and you had some good delivery. The only thing is, I felt that at the beginning your delivery needed a little bit more energy, but it got better as the time went on. But then, as it got more energy, you got very fast. So you needed to slow down, and you needed to pause between your points. One point, as you move from one point to another, take your time and slow down a bit, okay? But very good eye contact, very confident delivery, which was good. I thought you made a good attempt to respond to my questions, and there was a decent answer. I thought that you delivered with conviction, and some very nice signposting and very good introduction to your submissions. The only, or the main issue is that you need some more law to support your submissions. You don't deal with law at all in your skeleton, i.e. the lawfulness to swerve to avoid a cat, nor in your submissions, nor do you deal with any law in relation to acting promptly and the second limb of the overriding objective. Sorry, second limb of 13.3. So that has let you down slightly, but you've got good proposition followed by evidence and conclusion. That was good. So some good persuasion there. So you're on the right track. I just want you to focus a little bit more on your delivery. I want you to focus on your structure. Don't mix numbers and bullet points, because it's very difficult to then refer to it. Try and adopt the structure that we suggest from the sample that will be available at the end of the week, and think a bit more about the law and how to apply the law to your case. But well done.